everybody. Let's get our Wednesday, January 20th meeting started, and we will begin with requests for bill introductions. Any members have a bill that they would like to request? Not seeing anyone moving or anyone's hands up. We do have a couple people joining us this afternoon. Ethan, you're up first.
Thank you, Mr. Chair and members of the committee. My name is Ethan Belshi, and I'm the Government Relations Manager for the Department for Children and Families. On behalf of DCF, I'd like to request 21 RS 0339 for introduction. This bill amends statutes related to the circumstances under which DCF can release information when alleged abuse or neglect results in a child fatality, and would add an additional circumstance under which DCF can release that information.
Committee, any questions for Ethan or any objection? Not seeing any that will be introduced. Thanks, Ethan, for joining us. Next, we have Sean Miller.
Thank you, Mr. Chairman. Can you hear me?
We can.
Very good. Thank you. Introduction today on behalf of Leading Age Kansas and the Kansas Healthcare Association. It is RS 21 RS 0459, and that is related to adult care homes and COVID liability.
Any questions, committee? Seeing none. Any objection? If not, we will get that one introduced. Thanks, Sean. Anyone else here with us? You're welcome. Anyone else here today have a bill they'd like to introduce? Okay, not seeing any. We will get moving. We've got two bill hearings today, committee. The first one is on House Bill 2001. I will open that hearing and ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2001 creates the crime of sexual extortion. So this new crime would be communicating a threat to injure the property or reputation of another person, a threat to commit violence against a person, or a threat to distribute an image or video of a person of a sexual nature or in a state of nudity, either with the intent to coerce the person to engage in sexual contact or produce a sexual image. In that case, it would be a severity level 7 person felony, or if that conduct causes the person to engage in the sexual contact or actually produce that image, then that would be a severity level 4 person felony. The bill also provides that a person who commits that crime when one of the parties is less than 18 years of age would be required to register for 15 years as a sex offender under the provisions of the Kansas Offender Registration Act. And I can take any questions.
Questions for Natalie? Not. Representative Heiberger.
Thank you, Mr. Chair. The penalties, the crimes described here overlap with any existing statutes. Did you hear my question, or did it make sense?
Yes, sorry, I was just looking something up and getting unmuted here. Yes. So I would say, like, we already have the crime of extortion on the books, which is a lot more broad. It doesn't require the sexual nature. And so this new crime, while it would be more specific, would already be currently covered under the currently existing crime of extortion.
But it would impose harsher penalties if there's a sexual component to it, or not?
Let me find. So extortion is a severity level 7 non-person felony. So this would be a 7 or a 4, depending on whether they actually followed through with the sexual contact or with providing the image. But this would be a person felony, whereas the normal extortion statute is a non-person felony.
Thank you.
Any other questions for Natalie? I don't see any hands raised, so thank you, Natalie. We'll move on to proponents. First up, we have Kate Owen. Kate, I see you on here somewhere. There you are.
Yes, sir, I'm here.
Thanks for being here.
Thank you. Can you hear me okay?
We can.
Great, thank you. Good afternoon, Chairman Patton and members of the committee. My name is Kate Owen, and I'm an attorney with the law firm Orrick, Harrington, and Sutcliffe. I'm here today on behalf of my client, Legal Momentum. I'm testifying in support of House Bill 2001, introduced by Representative Owens. I'm a pro bono counsel for Legal Momentum. At Orrick, we have assisted Legal Momentum for several years to work together with lawmakers across the country to close loopholes in existing laws and ensure that sexual extortion, which is a form of sexual assault, is criminalized. Legal Momentum strongly supports efforts to criminalize sexual extortion in Kansas. We thank you for your time in addressing this important matter, and we would like to thank Representative Owens for his work and support on this issue. So sexual extortion is not a new crime, but it is one that has sadly grown at a rapid pace in our current digital age, as offenders are increasingly using technology and the internet to reach victims in Kansas and beyond. Instead of demanding money or property, the offender here demands sexual images or in-person sexual contact. In its modern online form, offenders often obtain private, often sexually explicit images of their victims by various means, such as hacking into their smartphones or into their computers, or by pretending to be a peer or a friend on a social media site. And once the offender gets a hold of an intimate image, they use a variety of threats to coerce the victim into producing more images or engaging in in-person conduct with them. While offenders may threaten the victim in a variety of ways to coerce more images or sexual conduct, a common threat is for an offender to say that they will distribute the images to the victim's friends, family, their job, all over social media, unless the victim produces and sends them more. Every time a victim is forced to create and provide sexual images against their will, or meet in person for sexual acts against their will, the victim is sexually assaulted. Victims of this form of sexual assault suffer harm like that of any other sex crime. The rising reports of sexual extortion that we hear about are alarming, in particular because, like other sexual assault crimes, sexual extortion is likely underreported. Also alarming, sexual extortion has been used by human traffickers as a way to coerce and recruit victims into human trafficking. As we have seen with other forms of gender-based violence, including domestic violence during the pandemic, it has created circumstances that have made victims more vulnerable to sexual extortion, as most of us have been even more reliant and heavily using technology than ever before. So with legal loopholes in place, many offenders believe they are shielded from prosecution by laws that have not kept pace with the innovations of the internet. So with House Bill 2001, Kansas has the opportunity to lead on this issue and modernize its laws to criminalize sexual extortion, thereby capturing this method by which offenders are abusing their victims. And this bill creates a clear new statute that will recognize this crime. It's not only a crime to extort money or property, but it is a crime to extort sexual conduct and sexual images. And while sexual extortion it does not fit into a traditional extortion statute, as Ms. Scott was saying, the higher penalties that you see here are important. The sex offender registration piece of it is also important. And it is a sexual assault, and it does not belong in a traditional property or money-based extortion statute. So I thank you so much for your time. And I would like to also say that Legal Momentum supports the proposed minor amendments to the bill that have been submitted by Representative Owens, or that will be submitted. And I want to thank you for your time today on behalf of Legal Momentum. And I urge you to support this important legislation. And I thank you so much, and I'm happy to answer any questions.
Very good. Kate, we'll wait till the end of all proponents and then come back with any questions.
Sure.
Next, we have Greg Smith.
Chairman Patton and members of the committee, thank you very much for allowing us to testify today. I'm Greg Smith, Special Deputy for Government Affairs with the Johnson County Sheriff's Office, and we are in support of this bill. I did a review over the last 5 years, and we've definitely had an uptick of this type of crime that the Sheriff's Office has responded to. Looking at just other agencies in Johnson County, I see a similar uptick with them as well. It's an easy crime to commit in today's world. All you need is a tablet or a cell phone or a computer. And a lot of this activity is going through apps on a phone, apps that you may not even think of as being something that somebody would use for that. Discord has become one that we've run into a lot. It's supposed to be used by people that are gamers and that as a way of discussion and that type of thing, but a lot of things go on behind the scene. And so we're concerned about the uptick in this, and we think that 2001 is a good tool that we would be able to use. We do have some concern about juvenile on juvenile activity like this. I know in the past the legislature has worked very hard to try to keep juveniles off the sex offender registry. But I understand that there may be something in the works for that. But overall, we're supportive of the bill, and I'm happy to stand for questions at any time.
Very good. Thank you. Next, Sarah Russ Martin.
Thank you, Chairman Patton. Thank you, committee. Thank you, Ms. Owens and Mr. Smith, for giving a lot of the context so that I can make my comments short. And it's nice to be with you again today. I was just here yesterday, so I missed you all. All right. Sarah Russ Martin. I'm with the Kansas Coalition Against Sexual and Domestic Violence. I'm the Legal and Policy Director, and we represent the 26 local programs doing the work on the ground in your communities you serve. So we support the passage of House Bill 2001. I think I testified on this last year as well, that this is a form of blackmail, a form of corruption, threatening violence and wrongful threat of economic injury and threat to a person's reputation. These are all forms, as Ms. Owen said, of sexual violence. I think that what I will say that I think it just added value to what's already been said is that a lot of times this information is also garnered by hacking. So this isn't just about somebody sharing information with another person, but people are getting this information in unlawful means already and then threatening the person they have received it about or who it is subject to, and then saying, unless you do these things, I'm gonna release it. And distribution is the most common threat. I worked on a case myself that was much like the case I cited in my written testimony, where it was a webcam issue, and a young girl did not realize, you have to look for the light to be on your webcam, and sometimes that isn't as noticeable as other times. She didn't realize that it was on and somebody was hacking into her room, and it was a complete privacy violation, right? She had no idea that somebody was watching her, and in fact they were taking record of those images, and then coming back to her and saying, as a minor, unless you do these things, I'm going to share this information with everyone in your school. I'm going to share this information she also was employed at the time. So I think that both of the other conferees have articulated this point, and that is that we are seeing this much more in the last few years than we ever did before. I think some of it is we're all more on our computers than we ever were before, but also just folks are getting more and more technologically savvy and more able to do this type of destruction to other people. And so I want to thank Representative Owens as well, and just say that I also want to make this quick connection between revenge porn, which your House and Senate has passed already, and this bill. And revenge porn is implicated when and if the perpetrator shares those explicit images, right? Once that sharing happens. This bill, though, is covering an area that isn't already covered in our law, right? And that is that it would hold a perpetrator accountable for all of the acts that went into gathering or obtaining those images. So I think it's sometimes those get convoluted a little bit and connected in ways that they aren't necessarily. So I just wanted to make that distinction, and I appreciate the time. Thank you, Mr. Chairman, and all the members of the committee, and I will answer any questions at the appropriate time.
Very good. Thanks, Sarah. Committee, you also have written proponent testimony from Ed Klump and his organizations. I don't believe we have anyone else as a proponent. Do we have questions for either of our three proponents? Representative Humphreys. and then Heiberger.
Thank you, Mr. Chairman. And this possibly is for Natalie, but it was something that Greg Smith brought up that I was wondering about, but I didn't jump on it immediately with Natalie. Natalie, in the bill, when it says that if either party is under 18, then they would have to register on the sex registry. And so, if the perpetrator is under 18 and the other person is older, how, and we put 15 years, does that conflict with anything else that we already have in our statutes as far as the minor registering on that registry? And just, yeah. So, and I know that's maybe kind of how we're writing our bills now with either under age, but if you would just speak to that, or is that okay, Mr. Chairman, if Natalie answers that? Thank you.
Sure. So thank you, Mr. Chairman. So you're right. And Representative Humphreys and Representative Jennings have a lot of familiarity with this because of our work over on the Judicial Council. So I'll explain a little bit of this. Right now, there's a section in our Offender Registration Act where certain crimes are registerable only when one of the parties is less than 18. Probably we tend to think about the victim being under 18, but that's not what the words say. And so that Judicial Council group has been working on that. But right now, that whole list of crimes applies when one of the parties is under 18. We have, in the past, made some exceptions for the registration requirement for juvenile offenders. So if you guys remember the sexting legislation that we worked on a few years ago, we actually carved out that folks that are adjudicated as a juvenile offender for that offense are then not required to register. But as drafted right now, if you had either party under 18 engaged in this conduct, then the offender would be required to register for that 15 years.
Representative Heiberger.
Thanks, Mr. Chair. My question is for Mr. Smith. You indicated that you're seeing a lot more of these crimes. So my question is, are you seeing conduct that's not being prosecuted because the current law doesn't cover it, or are you seeing things that are being prosecuted under other statutes?
Okay, Representative Heiberger, I caught part of your question. I heard the part about where I indicated that the crime was up, but I missed the last part. I'm sorry.
I'll just say it again. Are you seeing conduct that's not being prosecuted because current law doesn't cover it, or are these things being prosecuted under other statutes?
I'm not saying that the conduct isn't being prosecuted. The prosecutor's office has decisions to make when they have those types of crimes. And actually, probably the better person for that question, even though he didn't testify, but I see him here on the call, is my district attorney, Steve Howe, who would probably be able to answer that much better than I could.
Yeah, thank you. If Mr. Howe is willing, I'd like to do that.
Representative, the statute we use right now is blackmail. And so many times we'll use that statute to prosecute an individual for this type of behavior that was discussed. And I will agree with Greg Smith that we are seeing a real uptick in these types of cases. And there is a good portion of them that are being committed against minors. So it is, I see the purpose behind the bill. We do charge things currently, but this would provide, I guess, better direction and specificity to the law to cover this type of conduct.
Okay. And are the activities against minors not covered under the existing sexting law?
No, they are. But I think what's important is, and I haven't read this entire bill because I wasn't prepared for it, but I think it's important to cover minors and have that articulated in the bill, what you do with those situations where the victim or the suspect is a minor. It's not covered under the current blackmail statute.
Thank you.
Any other questions, committee? Not seeing any. We do not have any.
Mr. Chairman, I have my electronic hand raised over here.
Where's it at? There it is. I see it now. Representative Jennings.
A couple questions, and I would invite, with your permission, any of the three proponents to respond. I would be curious in knowing whether or not any of the proponents think it would be a good idea for any offender under the age of 18 to be required to register as a sex offender for 15 years if they were adjudicated a juvenile offender for this particular offense. And I guess to follow up on that, if there's no one that thinks that's a good idea, do you think it might not be appropriate in this case?
Hi, this is Kato, and I'll respond to your question, sir. I would need to speak with my client about that, but that's an excellent question. I think from an initial reaction that it would likely not be appropriate for a minor under 18 to register.
Thank you for that. And then one more question, Mr. Chairman.
Yes, sir. Go ahead.
And maybe Ms. Owen, I think is your last name. Is that right?
Yes, sir. That's right.
I guess I would ask you whether or not you are aware of any research that would suggest that offender registration is an effective means to reduce offending behavior.
I would have to defer to the legal experts on that, particularly in Kansas. I'm not, don't currently have enough information to answer a question on the sex offender registration right now, but we can look into it and certainly respond back.
That would be great. If you find any research that supports the notion that offender registration reduces the likelihood of reoffending or offending behavior, I'd love to see it.
This is Sarah and the other conferee, and I will just say that most of the research that I have seen that I'm also happy to work with Ms. Owen or either provide independently shows that registries are most often most helpful in making the public feel better and aren't always as effective in actually decreasing recidivism. Obviously, it's not true in every case. And I would agree with the under 18. Having teenagers myself, I just think that decision-making, the frontal lobe isn't fully developed. I don't know that we want to go down the route of having somebody register for 15 years for conduct that could have been really violative and horrendous. Nevertheless, was also misguided and immature. So I think we have to, weigh all of that. So I just wanted to offer.
Any other questions for the proponents? Not seeing any. Is there anyone here as a neutral or an opponent? Not seeing any of those either. I'm going to close the hearing on House Bill 2001 in committee. Just a little guidance or where I'm thinking we'll head on this one. The Judicial Council has been doing some work on the registration issue, and so I think we'll wait to hear what their bills are, and then I'll make sure and work with the chair, which is Representative Jennings, and Vice Chair Representative Owens on this issue, and we'll try to come up with some ideas to work on that registration issue along with the proponents. So anything you guys have to add, make sure you let the three of us know. Moving on, I'm going to open the hearing on House Bill 2071. And ask Natalie to give us a brief overview.
Thank you, Mr. Chairman. House Bill 2071 would increase the criminal penalties for stalking a minor. So the bill seeks to amend KSA 215427, which is the crime of stalking. We amend it to add a new provision for intentionally engaging in a course of conduct targeted at a specific child under the age of 14 that would cause a reasonable person in the circumstances of that child or a reasonable person in the circumstances of an immediate family member of the child to fear for the child's safety. Violation of that new stalking provision would be a severity level 7 person felony on a first conviction, and then a severity level 4 person felony on a second or subsequent conviction. And I can take any questions.
Any questions for Natalie? Representative Carmichael.
Okay, I apologize, Mr. Chairman. When we're in the normal app, you can use your space bar just like a push to talk switch, and it really works great. But now that we're in this browser app, it works differently. I apologize. Ms. Scott, has the committee seen this or similar legislation before?
Mr. Chairman, this one is not a reintroduction of a previous year's bill.
That was my suspicion. Thank you, Ms. Scott. Thank you, Mr. Chair.
Any other questions for Natalie? Not seeing any. We will move on to our proponents. And the first up is Representative Lynn.
Thank you, Mr. Chair. Thank you for allowing me to speak to your committee today. As we heard from HB 2071 looks to amend KSA 21-5427 by increasing penalties for stalking a minor. This existing law was passed in 2008 and was known as Jody's Law. Jody Sanderholm was 19 years old when she was abducted, raped, sodomized, and brutally murdered here in Kansas. The man who was responsible for her gruesome death had multiple restraining orders against him. However, at that time, there were no laws in place that would allow the police to arrest him for stalking. So this law strengthened the legal definition of stalking while increasing punishment and allowed law enforcement agencies to better protect their citizens. So Malatha, who's going to tell you their story, one that no one should ever have to experience, let alone tolerate their accusers to be set free after committing these heinous crimes against children. And HB 2071 strengthens current law by increasing criminal penalties for stalking a minor. We're also going to hear from Steve Howe, the district attorney from Johnson County, who can give us a better understanding of the legal reasonings for this law and how it's imperative to close the loophole that the accuser used to be able to get away with this for years.
Thank you, Representative Lynn. Kristen, you're up. There we go.
Can you hear me? Okay.
Yes.
So, my name is Kristen Antonucci, and I'm honored to speak in support of House Bill. House Bill 2071 on this historic day. I look forward to sharing our personal story and need behind this bill to increase criminal penalties for stalking a minor. I have been a resident of Kansas almost my entire life. I'm a small business owner, a wife, and a mom to 3 kids. On March 10, 2020, it was just like any other Tuesday. I went to pick up my children from their elementary to shuffle them around to after-school activities. My children hopped into the car just like they always do when I turned around to notice that my normally jovial oldest daughter had a look of despair on her face. I immediately asked her what was the matter, and she indicated that something bad had happened at school that day. She explained that her friends and classmates had approached her on the playground at the end of the day recess and told her some upsetting news. She said that she didn't want to talk about the information she received in front of her little brother and little sister. It was too inappropriate. She had tears bubbling in her eyes and tears running down her face. I could hardly bear waiting to hear what had made her so upset that day. Once we arrived at our destination, we stepped out of our car and she told me that her classmates who were 9 and 10 years old had let my daughter know at recess that they believed their 4th grade teacher had been taking inappropriate photos and videos of my daughter, of her bottom and of her private areas in class. They had seen him for months sneaking his phone or iPad out. He would look around and video and photograph her from behind when she was not looking. The sweet friends had also indicated that they had told their parents. One girl who was 9 years old had been so smart that she even tried to switch desks with my daughter the week before to try to remove her from harm's way. I was in complete shock and in disbelief. After speaking with the school, they did indicate that they were indeed investigating his behavior and allegations. The next morning, the teacher was confronted about what the girls had been witnessing. My daughter's 4th grade teacher admitted to having an obsession and an infatuation with my 10-year-old daughter. He admitted that he did, in fact, use his classroom as a place to photograph and video her for his own gratification. We were all shocked, stunned, mad, and upset. He had taken hundreds upon hundreds of videos and photos of her on the playground, walking down the hall, eating lunch, tying her shoe. Upon interrogation, he further confessed additional alarming information, and he admitted that she fit his type. She was not the first minor student he had photographed, but ultimately his behavior had escalated and had escalated the furthest with her. A third of all stalkers have more than one victim. How he described her and her childlike body disturbed law enforcement. The things he said about her in almost a boastful way were highly alarming. In my mind, he would have been arrested right there on the spot. We were in utter shock to know that a grown man in his 50s with children of his own would walk free that day after admitting that he viewed a child as sexually attractive. That he would violate her trust and use his position of authority to take photos and videos of her backside and rewatch them when he went home. And he'd been searching on her and our family. He had researched enough to know to get away with and didn't believe that because he hadn't touched her or at that point and she was closing the pictures that he would be charged with anything. My anger quickly turned to fear. This man who had been stalking my child for the last 8 months and who had done enough research on her and our family was now walking free. He knew where we lived, where her activities were located, and obviously where she went to. This man's obsession for her had bubbled up so much that he had gotten sloppy enough for children to catch on to his behavior. Here is a man who was willing to risk it all. His job, his wife, his status within his church, and a relationship with his own children for an obsession with my child. What else was this man capable of? What other lengths would he go to? A forensic sweep of his personal electronics slowly came in. Day after day, we were briefed by our amazing child detective who would let us know what they found on his computer or in electronics. More photos of our child, additional searches for her online, looking up information on our family, looking up directions to her dance studio, which was just 1 mile from his home, multiple times, and looking up information on her extracurricular activities and other directions to other different places that she would go. Due to the ongoing court trial, we will not disclose any other information, but what they found was frightening and disturbing. My innocent 10-year-old daughter had to undergo police questioning. That day was really hard. She jumped on the trampoline and rode her bike before the detective arrived. My husband and I watched her play, wondering how a grown man could view this child as sexually attractive. She is a child. I watched in awe as she navigated the tough questions being asked while my husband and I sat in horror with tears flowing behind our sunglasses. The detective let her know that they were working hard to bring justice for her and described how laws in Kansas don't always protect children like they should. She boldly declared that day that she wanted to help us work on changing laws to help protect other children. That day we formed #NotYourDaughter. I began to sleep in the hallway between all 3 of my children's bedrooms at night to make sure that they were safe, to make sure that he didn't get to our sweet girl. The fear was consuming. An announcement that COVID-19 was shutting down schools that very week was welcomed. I didn't want to let any of my kids out of arm's length, and the shutdown was the best case scenario for our family. For 3 months, we lived in fear, hoping and waiting for him to be arrested. We were ready to breathe a sigh of relief. On June 12, 2020, the call we had been waiting for finally came in. We were notified that my daughter's 4th grade teacher would be arrested that day. I always took any calls from detectives or the district attorney's office in my car to ensure that our children were not aware of the details of the situation and I could never be overheard. I had to protect the innocence of my daughter the best I could. She is not in the room as I speak today. And as I walked back into the house that day after hearing he would be arrested, my daughter asked why I looked so happy, so relieved. I did let her know her teacher would be arrested. She gave me the biggest hug and said thank you. She went to the kitchen and made me a card, grabbed us 2 Reese's Pieces cups for us to cheer with to celebrate. We all felt this overwhelming sense of relief. We received another call from the assistant DA letting us know he would be charged with reckless stalking, a crime that carried a maximum sentence of 1 year, if that. with a $10,000 bond. Teacher was arrested and taken to the courthouse where he was officially booked and spent just a mere couple of hours at the jail. I don't think he even actually went behind bars. We were notified that he had posted bond and would be released without an ankle monitor or any sure way. The sense of relief quickly dispersed as the fear crept back in. Our elation turned to sadness, then to anger, then to fear. He was booked and then almost immediately released, where he is now angered and the bear has been poked. I felt more scared than I've ever felt. This man knows where we live. He has nothing stopping him from finding us. We decided it was best that night to stay at a relative's house as we felt more vulnerable than ever. That night, news that an Olathe teacher had been arrested for stalking his 10-year-old student hit the airwaves. We are still waiting for the outcome of our case. I had spent 3 months at that point with full intent to never tell our story, never disclose our identity. I watched as individuals and classmates who were aware of this story at no fault of theirs made assumptions about the case and story online. Because children were the ones that had reported him, our identity quickly spread. We decided with our daughter's permission to tell our story. Here's the thing, if you want to invoke change, it's impossible to do in the shadows. We quickly made it our mission to fight with law enforcement and Steve Howe in the district attorney's office to change Kansas laws to protect children. The innocence, emotional, and physical well-being and lifelong quality of life for our children should be valued far beyond protecting the bad guys. Our children are not meant to be preyed on by pedophiles that consume their innocence for their own sick gratification. This leads me why we are here today. We are so grateful for all the bipartisan representatives that have supported our cause. The original stalking bill, Jody's Law, was originated by a courageous family who lost their beautiful 19-year-old daughter to a stalker. He had preyed on her and her family, starting when she was just 15, 4 years before he ended up taking her life. We hope to take their law and enforce additional punishments for those that stalk minor children 16 and younger. Stalking is a prerequisite to more harmful behavior, and an actionable increase in punishment would help to prevent stalkers from engaging in additional behavior. 54% of victims of homicide reported stalking to police before they were murdered. Passing this bill would afford minor stalking victims the protection they deserve. We wish to give a voice to the often voiceless. We believe this can be accomplished by raising the statute to a felony level within House Bill 2071. At every turn of this process, we were shocked to learn that our children are not fully protected, whether it be similar circumstances, child molestation, or child sexual assaults. We never thought this would happen to our family or our child. Our family, with the help of law enforcement, the DA's office, and legislators, have made it our mission to update these archaic laws. I'm hoping this is not the last time you will see me fighting for the rights of our kids. This situation has made our elementary school child have to grow up way too fast, experience of loss of trust, nightmares, and no child should ever have to go through a situation like this, and if they do, the predator should be punished accordingly. Detectives indicated they believe this obsession with our daughter was increasing, is posturing to do something horrific to our girl. We are forever grateful to those brave classmates who courageously stood up for our daughter. There has been many times our daughter comes to us and gives us a big hug or tells us thank you for standing up for her. We want to take our passion to stand up for all kids. We thank you so much for your time and hope that you too will partner with us to keep Kansas children safe. We hope that you will agree that punishments need to be heightened to deter predators. We need to send a clear message to those that prey on our children that behavior like this has no place in our state. By passing House Bill 2071, we can begin the process of updating Kansas statutes to better prosecute those that violate our children. Enough is enough. Please join us today. Not our grandchildren, not our children, not our sons. Hashtag not your daughter.
Thank you, Kristen. I know it's not easy. I appreciate you sharing that story with us and being here today and for the work you're doing. We have one more conferee and then we'll come back for questions. District Attorney Howe.
Chairman Patton, thank you.
Hold on, what is it? I'm sorry, District Attorney. I forgot Adeline wants to speak and she's now appeared in the screen. So we're going to let Adeline here. Sorry about that.
Hello, my name is Adeline Antonucci, and I want to thank you for considering our bill today. I want to thank my parents, classmates, and those who have supported my story. I know a lot of hard work has gone into to keep kids safe. I was hoping to be able to visit the Capitol today, but look forward to visiting again very soon. Last year, I loved being my class student government representative, being a pedagog dancer, hanging out with friends on the playground, and playing foursquare at recess. I was shocked to learn from my classmates that a teacher had. The feelings I've had this last year are sadness, worry, fear, and confusion. I do not that feelings that kids should have to have, especially from an adult in a place that is supposed to be safe. I feel like no other kid should have to go through a situation like this. When my mom said she wanted to change the laws to protect kids, it made me feel happy. I wanted to help her pass these other kids can be kept safe, and no go through a situation like this. I would really support of this bill. If this bill helps even one other kid, then we have won. If one other person does a bad thing to a child, it is worth it. I am so thankful that my parents have been working really hard to protect me, and I'm hoping that I can protect other kids. Kids need to be safe, and they need to feel safe always. Just like my friends were the voice for me, let's be the voice for other kids. Let's let beauty come out of ashes. Thank you.
Good job, Adeline. Good to see you again, and we'll figure out how to get you in the Capitol sometime soon, okay?
Okay,
She just-
thank you.
You're welcome. Now we have District Attorney Howe.
Chairman Patton and members of the House Judiciary Committee, thank you for the opportunity to talk to you. Those of us who have been doing our jobs for a while and work on laws know that this isn't the first time that we found a loophole in the law that needs to be closed. And I know this committee and your members and previous members have always reacted quickly and appropriately when we find these loopholes in criminal law, which are taken advantage of by abusers. And so when this incident occurred, of course, we're all appalled by such conduct. That's the visceral reaction that all adults, and especially people who are fathers and mothers who are concerned about the welfare of their children, would act when they hear these types of facts. As the district attorney and my staff, one of the first things we do is like, okay, so how do we apply the criminal statutes to this type of conduct to hold the offenders accountable? It was at that time that we started becoming greatly concerned about two things. One, can we apply current law? And two, can we uphold the law? And three, are the penalties really appropriate for this type of conduct? And so the first step of our analysis was, can we take current laws and apply it to the facts in this case? And while we have filed charges of reckless stalking, we were deeply concerned about the current language in the law and whether we could hold up against scrutiny at both the district court level and the appellate court level. And in fact, the defendant, as we anticipated, and I talked to Kristen about this, would probably file a motion to dismiss the case because of a lack of knowledge. And that became a big issue under the current law, was there a knowledge requirement in order for someone to be stalked? And the law is not very clear on that. And if you think in this case, how is a child supposed to know that they're being stalked? And it did not make sense in our eyes to have that type of potential standard. Now, we fought that motion in district court. Luckily, we won. But there's challenges at the appellate court level. So what we're asking this body to do is strengthen the law so there is no doubt what your intent is, so that the courts can't misinterpret holes in the language and allow accusers to walk free. And so one of the things that we did, I sat down with Kristen and we had some various representatives like Representative Lynn, and we talked about what our options are. And I asked my office to do research across the country about what are the potential ways that we could either close the loopholes or create a new statute. And while there's different methods used across the country, really we came back to, why don't we take the existing statute, strengthen it, because it has fought the test of time at the appellate court level. And we all know that if we can use language and statutes that have been tested, we feel much more comfortable than trying to create new statutes. And so that's what we did in this case. And the knowledge requirement, as you can see in the one subsection under the law, we cleared that up. So there wasn't a requirement under the law that you have knowledge that the person is stalking you. Because if you think about that, that makes no sense. If the stalker is really good at his job, so he gets rewarded, so he's not committing stalking because the victim just doesn't know. And so by including that statute, we applied an objective test, and that objective test is the reasonable person test. That language has been used in other statutes and been upheld by our appellate courts. That's why we felt like that was the proper way to approach this. So if we take this and apply that reasonable person test, and if you notice, we use the language, if the person would reasonably know, or their family members. So like if you have a child, like in this case, or even a younger child who has no idea they're being stalked by an individual, that you don't need that knowledge requirement. And so that's why that was placed in there. The second, or the most important thing was, does it make sense to allow a penalty section to be the same for us adults as is if you're stalking a minor child? And that made no sense. And we know the Kansas legislature has always treated minors with special circumstances and enhanced penalties. And so one of the things that we did is crafted the statute, and we talked to Kristen about this, what are the appropriate penalties. And one of the things I talked to her about is we want to make sure that the penalties for stalking a minor are also consistent with some of the penalties for the other criminal statutes that protect minors, and make sure that it's not too high or low, but it fits within all the other criminal statutes. And so that's why we propose the penalty levels that you have before you. Now, there might be a question of level 7. Well, that is a presumptive probation case. However, in this instance, if we had this bill as our statute, that would allow us to still file what's called a departure motion. Because the teacher was in a special fiduciary relationship, that we could still file and depart and ask for prison versus probation. And so this flexibility in the way we crafted the penalty section gives us the ability in these special relationships that have been violated to still hold the abusers accountable, and also, if necessary, place them in the Secretary of Corrections. So those were the reasons for crafting it the way we did. And I think if you try to apply other criminal statutes or craft a new statute, the problem we saw was when you're talking about sexual exploitation of a child or other criminal threat statutes, you always run afoul of what about the First Amendment rights? And First Amendment applies not only to speech, but also conduct. And so by doing this under the stalking statute, we eliminate those First Amendment arguments, and we make a cleaner bill and a cleaner statute that we can defend. So I think, I'm not going to go too far, but I think that this is a no-brainer as far as filing this type of amendment. I think it makes sense. It affords the protections for all victims of stalking, but in particular for minors. And it really puts in balance that minors should be a more severe penalty than with adults. And so we're asking that this committee pass this out of committee and allow the House to take up this bill. I think it's one of those that makes total sense to protect the children who are our most vulnerable in our community from offenders like this individual. So that is all I have at this point, and I'm happy to answer any questions that you might have.
Very good. Thank you, sir. Committee, we have written proponent testimony from Ed Klump again and his 3 organizations. Is there anyone else here as a proponent? Seeing none, we will do questions for proponents. Representative Carmichael, I think you had your hand up. Yep, you do.
I have my electronic hand up. Thank you, Mr. Chairman. A few questions from my friend, Mr. Howe. I think he can hear me. I see his head there and I see him nod. Good. Good to see you again, Steve. As you know from the testimony of, I believe it's the Antonucci's, I hope I say this correctly, they had concerns about the circumstances of the pretrial detention of the defendant. And those concerns, I think, were twofold. First, that the defendant bonded out within a couple of hours on a $10,000 bond, which probably cost about a $1,500 premium or own recognizance. And second, they expressed understandable concerns that there's no ankle monitoring was ordered in this circumstance. So my questions regarding pretrial detention is, number one, was there a request for ankle monitoring that was denied by the judge? And number two, if we were to pass this statute in future cases, at least, would it likely change the outcome of that pretrial detention hearing? In other words, will this bill get to the result that these folks want as it relates to pretrial detention?
So to try to answer your question, Representative Carmichael, would it change the bond? I don't know if it would, because bond is set by the judge considering a variety of factors. Now, what I will say is that I know that the courts are pushing for amendments to pretrial supervision and bonds. And there's a big push about, well, people are presumed innocent, so we should have lower bonds, or we shouldn't have bondsmen. And this is a big push to the courts right now. And what I would caution is, you know, there are facts that we provide to the court in regards to bond. And we make requests. Now, the court doesn't have to follow our request for bond. We asked for a bond that we felt was appropriate for a Class A misdemeanor. And you also have to understand that we are in the middle of COVID. And so the courts were really cautious about instituting high bonds because they didn't want to fill up our jails. And that doesn't mean that that behavior is not egregious and horrific. But they had to put it in perspective of, okay, this case versus a murder case versus a kidnapping case. And you know, I know Kristen was upset by that, and that the bonds were low and that they didn't have an ankle bracelet on them. And I understand that. And quite frankly, I've been pushing back for some time with our courts about reducing our bond amounts for public safety reasons. So while we don't have a perfect system, I think this is a word of caution. These are the tales of, are you sure you want to go down what some people are suggesting is just release everybody out, charge them and release everyone. And I would say that this tale, all you have to do is go look at states like New York that have adopted this type of approach and what has happened to their crime rates and their violence in their communities. So I am one of the people that have been really pushing back on Judge Arnoldberger and some of the pretrial requests to eliminate bonds and release more people out, because it's these types of people. I think he is a threat. And we all know that people who are sexually motivated towards children are not easy to correct their behavior. That's why we created the predator system in our civil commitment through the Larned State Hospital. So we know these people are dangerous. And so do I have an easy answer for you, Representative Carmichael? No. Can I tell you definitively if we had charged it under this current proposal, he would have been incarcerated at a higher bond? I can't tell you that. And that's because of this big push to release more and more people out of custody. And so I would prefer that he be incarcerated, but that's not my choice. And I wish we would. Could we have done a better job of articulating our concerns? Sure, but the judge had all the facts. He had the affidavit available to him when he set his bond, and ultimately it's his decision. So my hope is that it's a word of caution as we move forward in considering some of these issues.
Well, Mr. Howe, to try to be more precise and concise, Did your office ask for ankle bracelet monitoring for this defendant?
No, we did not. We did not ask for that.
So this law would not have changed the outcome in that regard one way or another because your office didn't ask for the ankle bracelet monitoring that these victims wanted.
Well, Representative Carmichael, I will caution you on putting too much weight behind a ankle bracelet because I will tell you we've had numerous cases where ankle bracelets have been cut off, and it's not an assurance that that person will not reoffend or create problems for the victim. And so I think there's way too much weight put behind ankle bracelets. In fact, I actually think higher bonds are probably more appropriate than just an ankle bracelet. And in this case, I would say there was supervision by a supervision officer. And so while there was no ankle bracelet, there was a supervision officer that monitored that individual, and he had to do check-ins on that. So, I mean, there's different ways to supervise and monitor those individuals. It's no blanket assurance if you take one or the other.
Well, Mr. Howe, I want to assure you that I share your concern about the efficacy of ankle bracelets, and I probably do not support legislation, though, that would lessen the penalty for removing one of those that's floating around. But you have to understand that when victims come to us and they complain that someone was discharged from custody after 2 hours without an ankle bracelet, if the district attorney's office doesn't ask for it, I think it's the district attorney's fault, not the statutory scheme. And so I just, irrespective of the efficacy of ankle bracelets, this bill is not going to give these folks what they want because it's probably, number one, not going to substantially change the pretrial detention determination of the judge. And number two, if the district attorney doesn't ask for ankle bracelet monitoring, I suspect the judge isn't going to order it. Am I wrong?
Well, what does a bracelet have to do with this bill? I mean, what Christian's asking you to do is basically correct the law so it's clear that you can file a stalking charge and enhance the penalties. And so whether he got an ankle...
Did you listen to her testimony where she said that's one of the things that she wants to accomplish is not to have this man out on pretrial release and certainly not without an ankle bracelet? That's why we're here.
No, we're here because this law has a hole in it and it needs to be closed. And
this
we
law
need to be able to
fix the hole she's complaining about as it relates to pretrial detention, Steve. You need to get us a different law, one that will work.
Well, Representative Carmichael, that's why we crafted the law we did, because now we can defend that in court and make sure that we uphold the fact that there's not a knowledge requirement. If you recall my testimony, there's two components here. One, it allows you to have or does not require a knowledge component. The second thing is enhanced penalties. Now, there's a lot of people out on pretrial release, including people who have committed substantial felonies. And I don't always get my way as far as what the bonds are. The bottom line is, can we hold them accountable at the time of sentencing? And that is the key component. You're missing the boat here. It's not pretrial release. It's what we can do at the end of the game. Because really, that's the most important piece is, can we hold that person accountable at the time of sentencing? And it is that sentence conducive to the type of behavior that's articulated in the statute. That's our goal.
Mr. District Attorney, I'm not going to belabor this issue because the hour is late and I have other questions, but I think you need to listen carefully to the victim of this crime about what they're here for. Number one, it is in fact pretrial detention, and this bill doesn't help that situation. And number two, it is at the back end on sentencing. And this bill may well help that situation, but I think you need to listen to these folks because I think they're being led down the primrose path by some folks who aren't willing to explain to them that this bill does not fix the pretrial detention problem that they are complaining about. My second question, though, Mr. Chairman, concerns the bed impact statement. And I know we don't have Mr. Schultz here today, but the bed impact statement for this bill says this may or may not affect bed space. We may know later. And I don't know what we need to do to get a meaningful bed impact statement, or what we need to do to see what contingencies may change in the future that would allow the Sentencing Commission to tell us the impact. But a bed impact statement that just says this might affect the bed impact doesn't do this committee any good. Thank you, Mr. Chair.
Representative Jennings.
Thanks, Mr. Chairman. Mr. Howe, well, your testimony suggested that a part of what really made this even more offensive was that it was essentially a perpetrator who held a position of trust with the victim by virtue of being a teacher in the school. And we have in our statutes with respect to unlawful sexual relations some very particular fact scenarios that relate to those kinds of special relationships and abuse of those. I'm curious if you would have any thoughts on differentiation between offenders based upon special relationship versus somebody who's just a complete stranger.
Well, I think if you look at our departure statutes, it clearly has a component that if a person is in a special relationship or a special position with the victim, that it allows for a departure motion. And so this clearly would fit that criteria for the felony offense that we've asked this committee to pass out. On the misdemeanor, it's totally discretionary from the court, one, what the sentence is up to 1 year, and also whether or not that person serves any time. Whereas in the felony arena, we can use that departure statute to do one of two things, of course. Move that person out of a presumptive probation way into presumptive prison, or enhance those penalties depending on the situation. And so I think this statute or this proposed bill allows us to have that flexibility in these special circumstances that we do with other felony offenses, which violate people's fiduciary or special relationships. And so I do think this helps us in that arena.
Thank you for that. Appreciate it.
Any further questions, committee? I'm not seeing any, so we will move on. I don't have any neutral or opponent conferees listed. Is anyone here a neutral or opponent? Seeing none, I will close the hearing on House Bill 2071. Committee, that's all of our work for today. We have, assuming you're all nice to me on the floor tomorrow, we will have committee at 3:30, and we have two bills scheduled from Legislative Post Audit. I am hoping to be able to work House Bill 2008 from gosh, was that just yesterday? I think it was yesterday. That's Representative Victor's and Representative Haswood's bill, but we'll see what time allows. But have that ready. I guess you don't have to bring your files anymore; they're online. But that is it. I will see you all at some point in the morning. Have a good evening. Our meeting's adjourned. Thank you.